Afternoon, everyone. I'm Christina Lawson. I'm the Vice Chair of Panel B. We are going to go ahead and get started here. I'm going to call this meeting of Panel B to order and would ask that roll be called.
Dr. Bollock? Ms. Lawson?
Here.
Dr. Gonadev?
Here.
Dr. Kraus?
Here.
Dr. Levine?
Here.
Ms. Hine?
Here.
Ms. Sutton-Willis?
Here.
Thank you. We're going to skip over agenda item 2, election of panel chair and vice chair, until our chair arrives later this afternoon, which takes us right into agenda item 3, and I will turn the proceedings over to Judge Johnson.
Good afternoon. I believe that the procedures for this afternoon have been distributed to the parties so that you understand that you have a time limit on argument. Is that correct?
Correct.
Correct. Yes.
Okay. Could you state your appearance for the record?
Good afternoon, Your Honor and board members. My name is Lori Forcucci. I'm the Deputy Attorney General representing the complainant.
My name is Hugh McCabe. I'm from the law firm of Neil Diamont. And it is my distinct privilege to represent Dr. Mosel here today.
And we're here regarding, in the matter of the First Amendment accusation against Joseph Mosel, M-O-Z-A-M-D. The case number is 800-2014-002292, OAH number 2017010264. Our location is the San Diego Marriott, Mission Valley, and the address is 8757 Rio San Diego Drive in San Diego. I would like to commence with a brief summary before you begin argument, counsel, just a brief summary of this case.
Yes, Your Honor. This is a standard of care case that was brought before the medical board, and the decision and order entered was a finding of gross negligence against Dr. Mosel, and discipline was issued against his license by way of public reprimand. So it was a one-patient case, and there was an instance alleged and found in the proposed decision of an act of gross negligence. Is that what Your Honor was wishing to hear?
Yes.
Thank you.
You may proceed.
Thank you, Your Honor. Again, Lori Forcucci, Deputy Attorney General, on behalf of the complainant. The proposed decision was issued after a full hearing on the merits. The administrative law judge found that clear and convincing evidence supported allegations that on a given date, September 28, 2012, Surgeon Dr. Mosel committed an act of gross negligence by leaving his hospitalized patient, whose initials are JL, at the hospital without having provided surgical backup before he left. The reason he left was that he had decided mid-afternoon that he would travel 100 miles from El Centro to San Diego, have his car serviced at Sears, and possibly do some shopping and some errands, and then return to El Centro. In so doing, the complainant has alleged that the respondent violated the standard of care because a reasonable, prudent physician would not have left the patient hospitalized under those circumstances. The standard of care is determined according to expert testimony. And in this case, we can begin by discussing points in which the experts agreed. For example, both experts agreed that timely patient care was the standard of care. Similarly, they both agreed that a doctor who plans to be unavailable must arrange for another doctor to respond to his or her patient on a timely basis. As articulated by the respondent, Dr. Mosel's own expert, the standard of care requires a surgeon to be available on a timely basis for ongoing care, either personally or by prearranged coverage in one's absence. and to observe the hospital staff bylaws. And as we'll discuss further down in this argument, neither of those criteria were met. Let us talk a little bit about gross negligence. There was a finding of gross negligence, and there is a legal definition of that. The legal definition is the want of even scant care, or the lack of even scant care. So what we're going to be doing is looking at the behavior and the facts, what happened on that one day, and see if Dr. Mosel had showed a lack of even scant care. Similarly, we'll be looking at the weight of the evidence to see whether the evidence supported that allegation. We allege that, in fact, we argue in fact it does, and that all of the assertions in the proposed decision support that clear and convincing evidence prove these facts. We'll be talking about the evidence as we go. First of all, we're talking about surgical coverage, and surgical coverage was defined at trial. It was said, coverage means that you're going to have continuous care for your patient in order to maintain an environment of safety for your patient. Coverage must be available, affirmed as available, and the surgeon must be informed about the patient who they're covering. And we find that in the reporter's transcript. Both experts agreed that those were required criteria for coverage. There's some argument that is misleading, I think, or not misleading, but it's confusing. And that is when Dr. Mosel was offering his defense, he indicated that his coverage in general was found to be adequate. His coverage at the hospital was found to be adequate. Be that as a yes or be that no, as it may, we're really looking at one day. What did he do on this one day in September when he decided to leave this one patient? So whether or not the other coverage for other days is good or bad is really not relevant to this particular point that we're talking about here today. On September 14th, 2012, there was a patient who was 82 years old. He had had surgery, and he had had some post-operative issues. On the 5th day of surgery, he had had a mucus plug, and we find that on volume 2, page 20, lines 10 to 16, and there had been some issues regarding the health of this patient. Dr. Mosel himself said it is a very serious morbidity of to have a mucus plug. That is how he characterized it. Subsequently, he also said that he himself was surprised to find that the patient had been changed from ICU to the regular floor because it had been against his own advice. He thought the patient wasn't ready. We find that also in the transcript, page 23, lines 22 to 24, and that respondent was considering taking the patient back to surgery. On page 24, we know that Dr. Mosel himself characterized this patient as an extremely high-risk patient. So he saw the patient that morning, and he had advised that a wound vac be applied to the surgical, to this area where the surgery had been. And the wound vac had not been done. So he had some concern. But he called Sears, and they said, if you get over here in San Diego by 4 o'clock, we'll take care of your car. We'll take it. So he decided to see if he could make it over there by 4 o'clock. And so he went. And he didn't call anybody. He didn't call his backup people, his assigned backup people. He didn't call the emergency surgeon. And he didn't let anybody know he was leaving. He went and he took his cell phone, as was his the typical thing that he did, and he went out. As it turned out, the patient had suffered an evisceration. When the evisceration occurred, they couldn't find Dr. Mosel. And so then began a series of events trying to find somebody to take care of this gentleman's evisceration. So at 2:30 p.m., the nurse found that the patient was suffering from a wound decisions and evisceration. We have that on Exhibit 5, AGO 736. 2:30, the nurse tries to reach the respondent for the emergency. 4 calls are placed to his office, to his cell phone. Respondent said he didn't receive those calls. 2:55. Staff unsuccessfully attempts to call the backup surgeon. The nurse advises administration of the severity of the patient's situation and that the staff is unable to reach the surgeon. Again, Exhibit 5. 3 o'clock. The respondent receives a text message from the administration. He's about 50 miles east of El Centro, and we know this because the respondent wrote it in a letter to the board, Exhibit 5, AGO 739, and he did not call back immediately, though. That's another thing he wrote in his letter. He said he didn't call back immediately. 3:10, there had been no call back from the emergency room on-call physician, whose name was Dr. Batista, and Dr. White, who was the person who was assigned backup, nowhere to be found. He's out of town. 3:10, 3:20, Dr. Batista calls back. 3:28, Dr. Batista arrives back at the hospital. He wants to review the operative report, but it's not in the patient's chart. Somebody goes and finds the report, they print it out, they deliver it to the operating room. Now it's 3:35. Respondent calls from the earlier text message. He calls back, and he says at that point he is 50 miles out. He said he's 50 miles out when he received the text. He's continued for the next that many minutes to travel east to San Diego, west to San Diego. So he turns around and he comes back. The patient goes in at 3:45 to surgery. There's some argument in the respondent's brief to the effect that, there was some argument by the respondent's expert at trial that respondent could have or actually was present when the patient was wheeled into the hospital. We would find that in the reporter's transcript, volume 1, on page 138, lines 16 to 21. However, the respondent, it shows that the doctor thought, their expert thought, that respondent got all the way back by the time the patient was in the hospital. But we know by looking at these nursing records that when he called back and the patient was about to be wheeled into the hospital in a couple minutes, he was still well over an hour out. So there's no chance that he was back in 10 minutes when the patient was then rolled into surgery. So,
You have 5 minutes.
thank you. One of the questions we look at when we have found a departure from the standard of care is how do we discipline a license? And oftentimes what we look at is has the person taken responsibility, right? Have they admitted that something went wrong? Are they remorseful? Are they rehabilitated? Do we have any assurances that this will not happen again? And this is entirely lacking in this particular case. Respondent said that even though he admitted he had not alerted any physician that he would be unavailable, and he admitted he had no coverage, he said that essentially he found everybody else to be at fault. He said, well, it was the nurse's fault, because if she had done the wound vac when he asked in the first place, none of this would have happened. Then he said, well, really, everybody there has inadequate coverage. He wrote, inadequate coverage of backup is endemic at the hospital. Indeed, surgeons under the emergency room contracts failed to respond in a timely manner in multiple occasions. Then he said, no, well, it's really the AT&T's fault, because if they had had good coverage and he would have gotten the call in the first place and he could have gotten back fast enough, no, it's their fault. Finally, he said, well, it's Dr. Batista's fault, because, hey, he's the person who's the on-call emergency room physician. He's the one getting paid, so he's the one who should have been there in the first instance. When you're looking to discipline a license, to determine whether discipline is in fact merited, one of the things we want to see is somebody accepting responsibility, or at least accepting their part of the responsibility. And this is entirely absent in this particular case. Again, we're looking at whether or not scant care was given to the patient. What would scant care have been in this instance? Dr. Mosel wants to go get his car fixed, or he wants to have it oil changed in San Diego. It would have been to say to somebody, Dr. Batista, to the staff, hey, I'm going to be gone for a few hours. I'll be gone for the afternoon. This is the status of my patient. He's had a wound opening. I took some stitches out. Keep an eye on him, or let me call you, or just know I'm not going to be here if something happens. That would have been scant care. And that's all he had to show. It's all he needed to do to keep his patient safe, is to provide scant care. According to law, the lack of scant care is gross negligence, by definition. Respondent had a responsibility, and that responsibility was to do everything within his ability to safeguard his patient, but he failed to do so. He knew he had a high-risk patient. He steadfastly yet resisted the idea that he could have improved his patient care by just alerting a backup that he was going to be gone that day. To the contrary, he diverted responsibility, denied responsibility, and as a result, the administrative law judge found that he committed one act of gross negligence on this day and disciplined his license by a public reprimand. Again, discipline is appropriate. There was an appropriate finding of negligence. Thank you.
Thank you. Proceed.
Thank you. Dr. Mosel would like to give a speech and present instead of myself for now, so I'll reserve my period for the 5 minutes I have at the end. If you have any questions that you want to directly ask Dr. Mosel, please feel free to do so.
Objection, Your Honor. Only the record is admissible in this hearing. No new testimony is allowed. New testimony is disallowed. Only a review of existing testimony.
I
That's
will
on the
point,
record and evidence.
I will point out that Dr. Mosel has a thick accent, so if you don't understand something, you can ask him to clarify what was said. Maybe that's a distinguishing statement.
I think the procedures here allow for him to make a statement.
Your Honor, I don't believe he's allowed to go off the record. Not that he can't speak, but he's not allowed to go off the record. He's not allowed to say anything that was not already said. It would be my objection if he goes off the record.
Indeed, and you can make that objection if he does
Yes, thank you, Your
make a
Honor.
statement about anything that was not said during the hearing.
Okay, thank you, Your Honor.
Could you raise your right hand, please? Do you swear or affirm that the testimony or statement you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And you understand the parameters, sir, that you're only allowed to make a statement about what was stated during the hearing?
Yes, ma'am.
Proceed.
Thank you. First, thank you for giving me the opportunity to present my case to you today. I have a license in California since June 1988, and I always held the medical board in high regard. I have no reason to think that any of you will be biased against me, and I trust all of you will have open mind. As it was said, I have an accent, so please feel free to ask me to repeat. I never get offended by such a request. And I also welcome questions from any of you. I would like to give you a brief background about the medical history for this patient, which is clearly in the medical record, which is the medical board had in her position. This was an 83-year-old gentleman who presented to the emergency room at the hospital on September 14, 2012. He had perforated gastric ulcer, acute anemia with hemoglobin of 6. He was cachectic, and he had advanced COPD. I took him to surgery, and I fixed his perforated ulcer, and he was admitted after surgery to an intensive care unit for 2 days. After that, he was moved to the floor, and in post-operative day number 5, when he was about ready to be discharged home, he had acute respiratory distress because of a mucus plug, and he had to be intubated and moved back to the intensive care unit under the care of the pulmonary doctor or the critical care doctor. And I used to round on this patient at least twice every day. He stayed in the intensive care unit for about a week on the vent. On September 26, when I examined his incision, I found that he had some pseudosanguinous drainage, and I was concerned about possible facial defect. This gentleman, because of his COPD, he was breathing from his abdominal muscles and intercostal muscles. He's a tiny guy, and especially if he had an episode of cough, you notice severe contraction or violent contraction of his abdominal muscles. And I was quite concerned about the stress on the incision. So when I found that he has some drainage and a possible facial defect or dehiscence, I requested wound vac to be applied to the patient incision. And on the 27th next day, the wound care nurse did not show up and no wound vac was placed on the patient. I gave my instruction to the nursing staff that I don't like the patient to be moved out of the ICU until the wound vac will be placed. But for some reason, he was moved without notifying me. Of course, I was not the main physician at this point taking care of the patient because he was under the care of the pulmonary doctor too and infectious disease. So on the 28th, I looked for the patient. I found he was on the floor, on a regular floor. I saw him at about 7:30 in the morning. I examined his incision and I took some of the staples out, and I discovered a facial defect of about 1 centimeter toward the upper end of the incision. I did a culture and I bought some water-dry dressing, and usually the standard of care for facial defect or dehiscence 2 weeks after surgery is non-operative management and observation. And wound vac would be a good option for these cases because you want to avoid doing surgeries at any cost. Again, I was very disappointed and upset that the wound care nurse still 2 days after the fact did not show up to put the wound vac. And they told me she's on her way. So I left, and during this morning, I called at least twice to the nursing station to inquire about the patient and how he's doing. I was assured his vital signs are stable, but the wound vac nurse did not show up yet. So shortly, maybe after 1 p.m., I left. I was on my way to El Cajon, and at about 1500, which is 3 p.m., I had a text message from Dr. Kumijin, the chief of surgery. He was doing actually, he's a cardiothoracic surgeon, and he was doing a case at Grossman Hospital. He was in surgery, but he picked up the phone. Immediately, when I got the text message from Dr. Kumijin, I called him immediately. And this in Exhibit H, which is Dr. Kumijin's letter to the medical board for January 2017. So I called him immediately after I got the text message from him. He told me that they have been trying to reach you from the nursing station at the hospital regarding your patient who had eviscerated. But because they were not able to reach you, so I did talk to Dr. Batista, and he is taking the patient to surgery. And he told me, you don't have to worry, you don't have to go back to the hospital because it's already taken care of. I told him, of course, I never got any phone calls from the hospital or any voicemails. And I thanked him for texting me. And as soon as I hung up with him, I did start driving back to the hospital. At the same time, I did call the nursing station immediately, and I talked to the nursing staff. They informed me that the Karen Love, the RN, and the wound care nurse showed up at 14:30, to check the patient wound to see if she will apply the wound vac, but when she removed the dressing, she found that he eviscerated. And we have been trying to reach you, and we left you several voicemails, and they also tried to reach one of my backup surgeon, Dr. White, who was out of town apparently, and they tried to, there was some confusion who is the ER physician on duty. So they contact one doctor, and he turned out not to be the one who was on duty. Finally contact Dr. Batista, who after reluctance agreed to take the patient to surgery. I asked to talk to Dr. Batista. He was at the nursing station, and I informed him about the patient, and I thanked him for agreeing to take the patient to surgery. Dr. Batista took the patient to surgery at about 14:45, and I was in a center shortly before. I think he took the patient to surgery about 13:45 or so, and I was in the area about 10-15 minutes after that. I started driving back as soon as I finished talking with Dr. Kumajan. I did not want to, of course, interrupt because the family was somewhat upset because they were not able to get hold of me. With regarding the backup coverage or the issues which we have, first, I found out that there was an outage from AT&T, and this was the reason I did not receive any of the phone calls. As a matter of fact, the voicemail messages which were left on my phone, I got it on the next day. And I have a letter from AT&T to document the outage, which they stated started on 27 and ended on the 29. This outage was also verified by Dr. Kumajan. And he stated also this in his letter. With the medical board initial accusation against me in December 2015 was lack of backup coverage. I was able to submit written documentation that in fact, I have backup coverage from two surgeons. One, Dr. Galloway, who is here, and the other one is Dr. White, who is a local surgeon. And as a result, the medical board or the DA amended the accusation from lack of backup coverage to inadequate backup coverage. What was used about me having no backup coverage, because I had some issues with the hospital in El Centro, which date to few years before then. And in December 2013, a year after, about 14 months after this incident, I left El Centro, and in fact, I did resign because of a hostile work environment for me. And as a result, they filed 805 report. That is how this matter came to the attention of the medical board. So on May 5th, 2015, I had an interview with the medical board. When you go to this interview, you don't know actually what they're going to discuss with you and or what cases they'll bring up. During this interview, I was asked, there was some cases, including this case, and I was asked if I have a backup coverage. I erroneously, because of lapse of memory, I stated I did not have backup coverage because this was 3 years after the fact, and I was, to be frank, confused about the specific for this patient, which happened in September 2012.
Excuse me just a minute. Counsel, is this in the record?
It is up until the last sentence when I got confused. The confusion part is not in the record. He did state that,
I'm asking his attorney, actually.
I'm sorry, I thought you were talking to me.
Yeah, the confusion part, I don't think that's in the record.
Okay, that's stricken and should not be considered.
Okay. So
Counsel, can you direct your client as to what he can talk about in this statement? And I'll give you a half a minute to do that. The board members are to disregard the statement about erroneously stated, forgot, all of that should be disregarded. Let's see.
Anyway, so I was able actually to submit letters to the medical board to state I actually had the backup coverage in September 2012. And that is why the medical board amended the charges, and this is in the record, from lack of backup coverage to inadequate backup coverage. Unfortunately, my statement in the transcript from 2012 interview with the medical board was used by the Dr. Child, who is the expert from the medical board, to claim that I was negligent because I had no backup coverage, which is incorrect. Also, the cross-examination of my expert, Dr. Murphy, was also based on the assumption no backup coverage. I was hoping to correct the record during the administrative hearing last June, but the DA chose not to cross-examine me, so I was not able to correct this record. Going after this,
Once again, is that in the transcript?
I'm not sure I understood what he said. I think when he
He said, I was hoping to correct the
DA
record, but the DA did not cross-examine me. That was the statement he made.
It's not in the record, and I think he meant the AG, but. He did not get cross-examined, but it's so I guess the transcript shows.
yeah,
that he
the
was
DA did not cross-examine me, that's why I
Excuse
was.
me just a minute, sir.
So the fact that he was not cross-examined is part of the transcript because it'll show no cross-examination.
Indeed.
There is no DA, so I think he must meet the AG.
Yes, I
So I'm
assume
gonna-
that as well.
Yes, so he was not cross-examined. This is true. Only examined.
Okay, also
But the statement, I was hoping to correct the record, is also stricken since it's not in the transcript.
True, Your Honor.
okay, the AIG or the ANG, which is administrative law judge, in his proposed decision, he's also referring.
You have 3 minutes left, sir. I apologize.
Okay, the fact is that the administrative law judge is stating that I did not show remorse or desire to, or I was defiant for the need for a change. Frankly, I don't know where did he get this from. There was never any question to me about the change or if I have any remorse. I sincerely regret that, and yes, in retrospect, I made an error in judgment by not notifying Dr. White or Dr. Batista about the patient and the condition of the patient, and that I will be leaving for a few hours, and if they get a call about the patient, to keep this in mind.
Once again, is that in the transcript?
I didn't understand enough of what he said, but I think it's generally in the transcript.
Let's see.
So if somebody got the impression that I was not remorseful, this was non-intentional on my part. Again, I sincerely regret that. The other thing is, because they are saying I did not show any remorse and I did not show any desire to change, the fact of the matter, I have been in private practice for surgery for 29 years, since 1993. And I work in many small and rural areas where I could be the only surgeon in town. And I never left my patient without coverage. I always have backup coverage from surgeon from the surrounding area if I have to leave the patient, if I have to leave the area. Otherwise, I will stay in the area.
Objection.
And I did the
Excuse me
same in El
excuse me
Centro.
just a minute.
Objection. The evidence doesn't show that he had local backup coverage. It just, the evidence is to the contrary.
I do have a local backup coverage.
Excuse me, sir, you have an attorney. I need to ask the attorney to respond.
Well, I think the record does show that there was coverage. It was coverage by the ER physician, the ER surgeon.
The record was, I think I just mentioned to you a few minutes ago, the medical board changed the accusation. In December, it was a lack of backup coverage.
Right, I understand,
I
sir.
provided them letter to show I have backup coverage, 2 letters. And based on that, they amended the charges from lack of backup coverage to inadequate backup coverage. So to say there was not in the record, it is in the record, it is in the exhibits. And I can give you the exhibit number. Exhibit D, letter from Dr. Ganaway, and also even the nurse in the floor, when this thing happened, she contacted Dr. White, who was my backup coverage. So even the nursing station, they knew I had backup coverage. It was just lapse on my part. I did not notify them before I left the hospital.
Thank you. And I apologize, I have not done the order that the medical board would like in terms of who should have gone first. So at this point, I will allow the respondent to make the 5-minute argument, and then you'll make your final 5-minute argument.
Okay. Thank you. Once again, it's my pleasure to represent Dr. Mosel. This isn't a case where there was any surgical lapse, breach of the standard of care. This case involves an issue of whether or not there was adequate coverage for the patient and whether or not Dr. Mosel has changed his ways or is remorseful in some manner or fashion. As a young lawyer, I can recall my mom telling me something once. It said, people change for 2 reasons. Either their minds have been opened or their hearts have been broken. This isn't a case of tragedy where someone passed away. The issue in this case is whether or not there was coverage and whether or not Dr. Mosel if there was no coverage, whether he practices now on a going forward basis, always ensuring that there is coverage. And so when you look at this case, initially, he had a Dr. Galloway, who was from San Diego, to cover him. He had a Dr. White that historically had covered him. Unfortunately, Dr. Galloway was in San Diego at the time. Dr. White was unavailable. But the hospital had a Dr. Batista on call, on paid call, to handle any surgical, ER, or hospital needs. The patient was stable at the time that Dr. Mosel left. Unfortunately, there was an outage noted and agreed upon by AT&T where he didn't get the phone calls initially. And so it wasn't until Dr. Kumjian reached him with a text that he responded, and he immediately called Dr. Batista to check on the patient and to answer any questions he could. So even though Dr. Batista wasn't notified, he was on paid call for both of those settings. And I think Dr. Mosel tried to make it clear in the last few seconds that he had to speak, was that in the future and moving forward, he has a policy and practice of always making sure there is coverage for someone if he has to go somewhere. And it is unfortunate that before he left, he didn't pick up the phone and just call Dr. Batista and say, hey, I'm going to be out of town for a little bit. Here's the story with this patient. If there's a problem, give me a call and I'll get right back to you. Unfortunately, that didn't occur. He understands that and has changed the way he practices. Dr. Mosel has been practicing for 29 years in small hospitals and clinics in areas where physicians do not like to go. He currently works out of the town of Needles, California, with the Colorado River Medical Society or Organist Hospital. Little places where there's few people to handle these things. Today, again, he mentioned his standard of practice for himself now is that on a going forward basis, He is going to always ensure that there is coverage for someone. When you have a case like this, it doesn't justify taking away his license. It doesn't justify taking things. He's never had a medical board matter. He's,
1 minute.
thank you. He's got a medical license in 12 states. He helps the poor people of these communities. This is
Objection,
the,
Your Honor, that's not part of the record.
that's all right, that's all right. Don't worry, Doctor.
What's not part of the record?
Who he helps.
So that portion is stricken, but he's licensed in 12 states.
Yeah.
Is that in the record?
That's part of the record. The CV is in there.
Thank you.
You know, this case, he's learned his lesson. Sometimes you win, and sometimes you learn. And he learned from this. I don't think it's necessary to have a public letter, but if the group feels that that's appropriate, then that's what you're going to do. But,
That's the end. Thank you.
thank you.
Thank you, Your Honor, and Board. The administrative law judge who heard this matter wrote that, by his own admissions, the respondent had no prearranged coverage in his absence. He said that not once, not twice, but 3 times in his medical board interview. And he was talking about the date in question. As we started to say in the beginning, this one day in September with this one patient. We're not talking about the overall 2 years of his privileges, and we're talking about this day and whether or not he contacted somebody before he left in accordance with the bylaws of that facility and alerted them to the fact that he was going to be gone and to the status of the patient. The ALJ wrote in his proposed decision, in fact, the cell phone problem taking place when respondent was 50 miles from the hospital was precisely why having prearranged coverage is so important. Physicians must reasonably anticipate such problems when they decide to travel, and they must ensure adequate patient coverage so that the covering physician has certain knowledge base concerning any hospitalized patient. And in this particular case, we know from the nursing notes that when Dr. Batista came to look at the patient, he couldn't even find the operative record. The nurse, whose name is Chad, had to go run and find it, and then he had to print it off and scurry into the emergency room to hand it off so that Dr. Batista, thank goodness, was there and available to handle this evisceration, which is a very serious event. I mean, what if there had been a car accident and Dr. Batista had been busy doing something else for a different patient? It's not like he's sitting on his hands waiting around. It's an assumption. It's an assumption that respondent made that when he left, that other people would be there to pick up the pieces if they fell apart. And that's not an appropriate response. And it's more than just an unfortunate decision. It's not unfortunate if you're the patient who's eviscerated. It's a very serious event. Again, I think the ultimate question is when you have questions for coverage, when do you do the coverage? When do you seek out coverage? It's before you leave. Dr. Moses' consideration was that, well, if somebody called him wherever I was, if I was 50 miles out, I'd just turn around and come back. I would deal with coverage when the bad event happened. But that's not when you have coverage. You predict where you're going to go. You're going to be gone an hour, and then you find out who's going to be watching your patients. It's all about the timing. And in this instance, Dr. Moses just assumed that if anything went wrong, he'd be able to handle it. And he did not, as the proposed decision says, reasonably anticipate such problems and do the best that he could for his patient to ensure the safety of that patient during his absence. All it would have taken was a phone call before he left. And he chose not to do that. It's the lack of scant care. It's gross negligence. Thank you.
Thank you. Any questions? Start from my left. Any questions? 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 Thank you.
Thank
Thank you very much. Let's go off the record. We're going into closed session, so we need everyone to step out.
Thank you.
Everyone, welcome to the Medical Board Panel B meeting of October the 25th, 2017. And we are going to be going into open session at 2:15, listening to the oral argument on non-adopted proposed decision. Mark Thomas Paskowitz.
On the record, this is before the Medical Board of California in the matter of the petition for reinstatement of the revoked certificate of Mark Thomas Paskowitz, MD. The case number is 800-2015-013480. The OAH number is 2017-090898. Our location is San Diego Marriott Mission Valley, 8757 Rio San Diego Drive. The way that we will proceed today is that the respondent will thank you. Respondent will make an opening statement, opening argument. The complainant will make a responsive argument, closing argument by respondent, closing argument by the complainant. Each party's first argument is 15 minutes, second argument is 5 minutes. There may be questions from me or the board members. The argument is limited to the record in the case. If there's anything that causes me to think that there is something beyond the scope of the record, I will interrupt and ask questions about that. I try to give notice at 5 minutes, and then again during the 15-minute argument, and then again during the and then 1 minute at the end, and the same during the 5 minute. It's really just the 1 minute before the end. And again, the board members or I can ask questions. Also, I believe the respondent is allowed to make a statement, but that statement is limited again to the record. Please state your appearance for the record.
Good afternoon, Deputy Attorney General Carolyn Westfall, specially appearing on behalf of Trina Saunders.
Good afternoon.
Mark Paskowitz.
Good afternoon. You may proceed. This is your opportunity to make your argument.
Thank you. Thank you. Thank you for this hearing today, and thank you for reviewing the documentation that I submitted at the previous hearing. In his presentation at my hearing, my attorney Scott Harris stated, quote, "The board is guided by the criterion for rehabilitation as articulated in the California Code of Regulations, Title 16, Section 1379.70, unquote. He outlined exactly how I had met the board's criteria for rehabilitation. I acknowledged the severity of the acts that led to my loss of license. I fully complied with the court-ordered probation. I was released from federal probation, and I continued to pay restitution. More than 12 years has now elapsed since the last incident that was the basis for my conviction. I've continued to work in the medical field since the revocation of my license, not in direct patient care, but in medical research, working closely with physicians and with data related to the care of their patients in clinical research studies. I've kept up my fund of medical knowledge, both as a function of my work in medical research and through many hours of formal CME. To directly address any gap in legal knowledge, I worked with an instructor from the UC San Diego PACE program. He created a personalized program for me called, quote, Regulations of Physician Billing and Business Relationships, unquote. More broadly, I've engaged in volunteer work in the community and made a major and ongoing effort to deepen my spiritual life. Over time, this has led me to the view that being a physician is more than an occupation. It's really an avenue of service to others as well as a privilege. I feel that I may not be a very good public speaker, especially in formal settings, but I don't want anyone to have the wrong impression about what's in my heart and what motivates me. So today I'm trying to be as clear as I can be. This whole case stems from my own criminal conduct. I am responsible for this conduct and take responsibility for it. I do not blame anyone else. I signed the provider agreement with Medicare, and I was fully obligated to follow each and every related regulation. Through my failure to do so, I committed a crime. My failure to meet my legal obligations was criminal conduct. I was duly punished. These are the facts. At the hearing in April, I made an effort to analyze what had happened. I was not trying to deflect blame onto others. Absolutely not. I accept the responsibility. But I have analyzed what happened, and I shared my thoughts at the hearing in order to learn from the events and to ensure that nothing similar would ever happen again. I've been fully open with people about these facts, especially those who supported me as character references. In asking each for a letter in support of my request for license reinstatement, I related the key elements of my case and the reason for the revocation of my license. In reply, some asked for further clarification with varying degrees of detail. Looking back, though, I note that a few of my references do not have English as a first language, and I wonder whether or not this led to any confusion in terms of details. I cannot answer this definitively, but I am absolutely certain that I did inform each one of the key facts. Several of my references knew details of my case in very personal ways. One cared for my pets while I was imprisoned. Another visited me while I was incarcerated. And another hired me to run his clinical research company after my release, with full knowledge of the record. These are people who know me, who know my character, and my dedication to the medical profession, before, during, and after my case. They have all stood by me, and I will always be grateful for their support. One side note, a question was raised by the Attorney General's office about one witness at the hearing, Dr. Gary Fisher, and that why he was provided with the entire case history. The answer is simple. We wanted to be totally transparent with him. We wanted him to be able to make his psychological assessment based on full information. As you know, I have had two cases related to my medical license. This one related to Medicare billing and a matter related to PA supervision. At their core, both were of similar nature. I entered into business relationships that involved legal requirements related to my role as a physician. Going in, I did not take the required steps to understand my legal and professional responsibilities. Because of this, I failed to meet my legal responsibilities. I entered into the two business relationships about the same time, 2001, 2002. It was the legal consequences of the two situations that played out sequentially over a longer period of time. In 2002, I began work at a physical therapy center. The PA case with the board was in 2004. From that point in time, I withdrew from any patient care at the center. Other doctors were hired to perform clinical duties. In the following year, 2005, I cut all remaining business ties with the practice. And it was in October 2008 that I learned of my indictment related to the Medicare billing items. I know that the Attorney General looks at this relatively narrow slice of my life from a decade and a half ago and draws certain conclusions. Thankfully, though, my life story did not end in 2004, 2005. In looking for a pattern, I would ask one to look at a wider period to include all of the past 15 to 20 years to the present. Yes, there were notable flaws, period. But I believe that a true deeper pattern has become stronger and stronger with each passing year. It is a pattern of dedication to medicine, to helping patients through work in medical research. In the name of fairness, I ask you to consider the view from this wider perspective. In a given year, there's about 20 new drugs approved in the US. Next year, the list is likely to include a medicine called burosumab, B-U-R-O-S-U-M-A-B. It is a fully human antibody that will treat a rare genetic disease called XLH, X-linked hypophosphatemia. XLH is an orphan indication, meaning that no currently approved therapy exists to treat it, and it's a condition that affects about 15,000 Americans. It leads children to be short and with abnormally formed bones and joints. You will see in my file that I was deeply involved working as a member of the development team for this, including as its leader. I helped lay the foundation, then managed the early clinical development of this program. It's an example of the type of clinical research work that I have done over the past 12 years. Oversight of this type of work is done by the US Food and Drug Administration and not the medical board. However, my clinical knowledge and years of patient care have been fundamental to success in this related field. Also, given the very tight scrutiny by the FDA over research work that's used to support new drug applications, I believe that it shows that I can and have performed my professional duties in an environment of very strict and close governmental oversight.
You have 5 minutes.
Over a long period of time. If the board does reinstate my license, I plan to become a physician investigator in clinical research studies. This role requires a medical license. The responsibilities of this role are clearly defined in the Code of Federal Regulations. Essentially, the physician investigator is documenting and assessing medical findings in patients who are participating in research studies. The timing of visits and procedures for this work are spelled out in detailed protocols which are pre-approved by the FDA, and the compensation is set in contracts before a study starts. There's no direct patient billing. There's no government or insurance billing involved. The work is paid for by private pharmaceutical companies. From 2002 to 2003, I cared for dying patients as a physician with a nonprofit hospice. Later, I also volunteered as a physician in a free clinic while working in the pharmaceutical field. These experiences were highly rewarding. They reminded me of the beautiful avenues of service open to physicians. Along with being a physician investigator, I hope to return to volunteer work at a free clinic in the future. Thank you.
Thank you. Proceed.
We're here today on a petition for reinstatement of a revoked license. And while the board has asked for argument from both sides, to be clear, the burden in this case rests on petitioner to show that his license should be fully restored. He sits before you not as a newcomer, but as what we call a fallen licentiate. And the burden is on him to present stronger proof of his present honesty and integrity than to someone seeking admission to the board for the first time. His burden is clear and convincing evidence to you of rehabilitation to overcome your prior adverse judgment. He's argued that the focus of this case ought to be not on his past conduct, but on the conduct since the underlying discipline. But that is not entirely correct. When looking to determine whether or not a person is rehabilitated such that their license should be fully restored, the California Code of Regulations provides that the board may consider the gravity and severity of the underlying conduct that led to the revocation of his license. And that just makes sense. Without fully understanding what he did that placed him in that seat before you today, how can you know whether or not he's been rehabilitated? Now, this case was not originally assigned to me. I'm covering for another Deputy Attorney General who handled the underlying proceeding. And other Deputies Attorney General handled the disciplinary proceedings before her. So I sit before you in the same position as you, having only reviewed the documents, the exhibits in the transcript in the underlying petition case. And I, like you must have been, was taken aback by the gravity of the underlying convictions he suffered in this case. Taking a broader perspective of his life and his conduct, I learned that he has an undergraduate degree in finance and accounting. He eventually went to medical school and became licensed by this board in 1992. Not long into his career, only 8 years later, he entered into a business relationship with a physician assistant, where he was the, quote, supervisor of that PA, but really what was happening was that PA ran the business, that PA treated all the patients, and then billed under petitioner's Medi-Cal number. And in return, petitioner received a percentage of the proceeds from that business. Shortly after that, he entered into a subsequent business relationship with a physical therapy group called Good Healthcare, Inc. Another relationship where petitioner allowed billing in his name for services he didn't render. Now, at some point, the medical board began investigating his relationship with the PA. He was put on notice that the board found that relationship improper in May of 2003 when the board filed its first accusation against him. Despite the accusation, his relationship with Good Healthcare, Inc. continued. In November of 2003, he entered into a stipulated settlement with the board to that first accusation and admitted wrongdoing regarding his relationship with that PA. Despite acknowledgement of culpability, the relationship with Good Healthcare, Inc. continued. His medical board probation went into effect on January 30th of 2004, and it included a 5-year term of probation subject to various terms and conditions, notably included an educational course, an ethics program, a practice monitor, and a billing monitor. Despite this oversight by you, his then licensing board, his relationship with Good Healthcare, Inc. continued. I'm sure you saw in the records, as I did, that while all of this was happening, the petitioner completed his MBA in 2004 with a focus on management of healthcare enterprises. Now, despite his undergraduate degree in accounting and finance, despite his MBA in management of healthcare enterprises, and despite being on probation with oversight by his licensing board, his relationship with Good Healthcare, Inc. continued for at least another year. Eventually, the feds also investigated that improper business relationship. They found his business relationship and billing practices to not only be improper, but illegal. In 2008, petitioner was indicted on 18 counts of healthcare fraud. Specifically, 18 counts of violations of 18 United States Code Section 1347, which is knowingly and willfully obtaining money from a healthcare benefit program by false or fraudulent pretenses. In 2009, he pled guilty to 5 counts of healthcare fraud. And as though he has previously characterized this conviction as aiding and abetting healthcare fraud, and he's argued that he essentially failed to oversee his billing, make no mistake about it. These convictions were serious. They were so serious, in fact, that he was sentenced to over 2 years in federal prison and ordered to pay almost $500,000 in restitution. While he sat in prison, the board filed another accusation against him for a whole slew of charges, but most notably including dishonest and corrupt acts. In 2011, his license was finally revoked. After his release from prison, he was placed on criminal probation, which ended in January of 2015. And just 2 months later, he filed the instant petition for reinstatement. That is the underlying conduct, the gravity of the underlying conduct that he needs to overcome with his efforts and evidence of rehabilitation. So what has he shown you? He has produced character letters. And when I reviewed the transcript, the investigator who testified and spoke to all of those character references, none of them knew the gravity of the underlying offense. And so you really have to call into question their opinion when they didn't seem to understand what he did that resulted in the need for the reference letter to begin with. He's engaged in a good amount of volunteer work, which is wonderful. But I saw in the records, as I'm sure you did, and as he's testified here for you today, that he was volunteering even before he went to prison. I'm not sure how community outreach is going to help him stay on a straight path now when it was insufficient to do so before. He attended a 6-hour PACE course on the best practices related to physician billing and business relationships. I'm sure this is a great course, but I'm not sure how a 6-hour course is going to miraculously cure his unethical, illegal billing practices, that his undergraduate degree in accounting and finance and his MBA with a focus on management of healthcare enterprises was somehow insufficient to do so previously. He produced an evaluation from Dr. Fisher, who essentially testified that he's competent to practice medicine and safe to practice medicine. But the practice of medicine involves more than diagnosis and treatment. As we know from the Griffiths versus Superior Court case, a physician who commits income tax fraud or files false fraudulent insurance claims has not practiced medicine incompetently. Nonetheless, that physician has shown dishonesty, poor character, a lack of integrity, and an inability or unwillingness to follow the law, and thereby has demonstrated professional unfitness. This concept is something that Dr. Fisher seemingly ignores in his opinion as to petitioner's ability to practice medicine safely. Petitioner did not have his license revoked for incompetence. It was for engaging in dishonest and corrupt acts. And Dr. Fisher even admitted that there's no way to know whether or not petitioner will engage in this type of misconduct in the future. And of course, we have the testimony of petitioner himself. The person who accepts responsibility for his misdeeds by saying he failed to realize he had a legal responsibility to oversee the billing done in his name. He failed to become knowledgeable about what he needed to do and his legal requirements as a physician in terms of the business side of medicine. You will be hard-pressed to find a physician with more education in the business side of medicine than someone with an undergraduate degree in accounting and finance and an MBA with a focus on management of healthcare enterprises. And yet this education was insufficient to prevent him from committing healthcare fraud. So you must ask yourself, is the evidence enough to overcome the gravity of his prior conduct?
You have 4 minutes left.
Protection of the public is the highest priority of the medical board. He was licensed for only 8 years when he began to engage in a scheme that landed him on probation with the board, and that the board gave him a chance. They put him on probation with a laundry list of conditions, made him go to an ethics course and practice monitor and billing monitor, and while being monitored by you, his illegal conduct continued to the point that he ended up in prison. And now he sits before you today and says, please, trust me again. There is no other profession in which one passes so completely within the power and control of another as does the medical patient. Such a profession requires its members to maintain the highest degree of integrity and honesty. When it comes to integrity, the best gauge is what a person does when nobody is looking. The board cannot police every physician every minute of every day. The public deserves to be treated by physicians who behave in ways that even when they can, they don't. And yet petitioner has shown you over and over again that when he can, he does, and even while you are watching him. The burden in this proceeding fits squarely on him, and that burden is high. I'm confident that when you weigh the underlying conduct against the amount of rehabilitation he has shown, you will find he has not met this heavy burden. And for that reason, we ask that you deny his petition. Thank you very much.
Thank you. 5 minutes.
I'm at a little bit of a disadvantage because I'm not an attorney, so I can only respond in a human way, as a human being. It's up to you. You know, if one looks at the 2002 to 4 window, I'd be hard pressed to make any kind of argument against what was just said. There were specific points that I would disagree with, but I don't have enough time to go through item by item. All I could say then is, looking forward as a person in my 50s, having experienced life, I've become much more aware of certain things than I was when I was in my 30s. We are each given certain talents and resources. We have an obligation to use these in ways that benefit others, not only ourselves. Being a physician is a privilege, and it's an opportunity for service that is open to relatively few people. Given this, I have special profound regret that my past conduct directly led me to not being able to meet this obligation in my work as a physician. And I am determined to make up for this. In closing, I'd like to share some very personal thoughts about what's in my mind and heart. More than anything, I see myself as a Christian. I know that I've been given many gifts, yet fallen short many times. I try hard to learn from my failings, and I try to steadily become a better person. Looking at these events from the past and at the future, I view things from a Catholic perspective. Specifically, I see them in the context of the sacrament of reconciliation and penance. Reconciliation is often referred to as confession, but it's actually a more profound process. In reconciliation, as I understand it, one is called to deeply reflect on misdeeds, whether it be things one has done or things that one has failed to do. And going step by step, to clearly define the wrong, to accept responsibility for it, and to work hard to repay the wrong.
Excuse me, sir. Does the transcript include information about reconciliation? At the prior hearing, was there discussion?
Not specifically, it was more in terms of spiritual life.
I think I have to limit that
Okay.
discussion, unfortunately.
Okay. So let me talk about then moving forward, at this point in my life, I've made great efforts to try to clearly define the wrong, to accept full responsibility for it, to work hard to repay the wrong,
You have 1 minute left.
to identify actions needed to prevent any recurrence, including adjusting my mindset and my priorities, and moving forward to commit to being a positive example for others. I can honestly say that I've done this process, and what I've gone through with respect to the issues related to the Medicare case and my license revocation. I was very gratified that Judge Dash evaluated all the evidence and reached the conclusion that my license should be reinstated. With a spirit of humility and thanks, I asked the board to allow me a second chance. Moving forward, I'm completely willing to follow whatever steps the board deems appropriate to ensure that I'm performing my physician role in a safe, proper, and knowledgeable manner. Thank you.
Thank you.
Rehabilitation is more than just words, and I do ask you to take a broader view of the last decade or two and consider all that he's done and all that he's promised to do before and didn't. Not enough time has passed to allow him back into this most prestigious profession, and public protection requires something more. Thank you.
Thank you. Any questions? Thank you. Then we can recess at this time and go into closed session, off the record.
The Medical Board of California, Panel B meeting of October the 25th. And we are going to have our judge, that Judge Johnson will be presiding over this meeting. And we're here to the oral argument of a non-adopted proposed decision of Mosel Mahendra Patel. And just for the record, his attorney will be on the telephone. And I'll turn this over to Judge.
The case number is 800-2016-0227-195. The OAH number is 20170203335. Our location is San Diego Marriott in Mission Valley, 8757 Rio San Diego Drive in San Diego. And my name is Valerie Johnson, and I will be presiding today. Please state your appearance for the record.
Carolyn Evans on behalf of the Medical Board of California.
Good afternoon.
Good afternoon.
And on the telephone? Are you able to hear us, sir?
I can barely hear, but I can hear you. It's Albert Garcia appearing for the respondent, Dr. Patel.
Okay, I'm not sure I can talk much louder without it being a problem. Does that help? Am I talking loud enough for you to hear me now?
Yes, you are, Your Honor. Thank you.
Good, thank you. And Mr. Garcia, you're appearing by telephone, and Dr. Patel is here in the hearing room. Is that correct?
Yes, Your Honor.
Good afternoon, sir. And the way this proceeding will go today is that there will be oral arguments. The respondent's attorney or the respondent will go first, 15 minutes. The Deputy Attorney General, 15 minutes. The respondent's rebuttal, 5 minutes, and the Deputy Attorney General, 5 minutes. The respondent is allowed to make a statement before the board, and there have been, one person did not, and there'll be an opportunity for questions. Do you understand, ma'am?
Yes, Your Honor.
And do you understand, Mr. Garcia?
Yes, Your Honor.
And also, and if you could speak up, just so we can make sure that the people in the room can hear you as well. I will give notice with 5 minutes, and then 1 minute before during the 15-minute argument. During the 5-minute argument, I'll give a 1-minute notice. You may proceed. Before you proceed, can you give us a brief summary of the case, ma'am?
Yes, Your Honor. This case came to us because it was an out-of-state discipline matter. Dr. Patel was disciplined in the state of Arizona for inappropriate prescribing, and there were factual findings made regarding the inappropriate prescribing, inadequate and inaccurate medical record keeping. And in Arizona, they disciplined him by way of a public reprimand and then required that he take an ethics course and a record-keeping course. We filed an accusation here in California based on that out-of-state discipline, and the ALJ in this case issued a proposed decision which recommends a public reprimand and a prescribing course. And the medical board at the hearing argued for a term of probation with various terms and conditions.
Thank you. Mr. Garcia, you may proceed.
Thank you very much. First of all, I would like to tell the panel members that I would certainly rather be appearing in person before you, but I am in a medical board hearing in Sacramento, and my request to have Dr. Patel's oral argument heard at the next quarterly meeting could not be accommodated, unfortunately. So we have the panel declined to adopt the proposed decision of Administrative Law Judge Mary Margaret Anderson, proposing a public letter of reprimand with a condition requiring Dr. Patel to complete a prescribing course. Now, the record shows that the Arizona board conducted a formal interview and concluded that Dr. Patel failed to maintain adequate records and departed from the standard of practice in his care and treatment of 2 patients who were seen between 2012 and 2014. Now, at the time that occurred, back in 2012 and 2014, Dr. Patel was serving as an independent practitioner with a firm called Life X Med, MD, LIFEX MD, which was a private practice offering hormone replacement therapy. At the time of the hearing, Dr. Patel testified that he was practicing there with that firm in Scottsdale, Arizona, and doing the hormone replacement therapy for that firm. He testified that the practice focused on elective cosmetic treatments, primarily for men seeking to improve their strength or stamina. He testified that at the time he joined Life X Med, he believed that his experience in laboratory medicine and other specialized training would serve him well in what he then regarded as an emerging field of medicine. But as he also testified, Dr. Patel came to realize that more needs to be known about the possible long-term side effects of hormone replacement therapy. And that was the reason why he chose to leave that practice back in 2014. After leaving that firm, Life X Med, Dr. Patel has been engaged in general practice, focusing on pain management and addiction medicine. He no longer engages in bioidentical hormone replacement therapy. At the hearing, Dr. Patel testified that he understands this board's concern with the conduct that led to the Arizona order, and he also testified to accepting responsibility for that conduct. In particular, he acknowledged that his documentation was deficient and testified to his understanding and appreciation that deficient documentation can affect patient care because subsequent providers will have an incomplete record of that care. He also testified that he gained valuable insight from the experience of being disciplined by the Arizona Medical Board. He testified concerning the record-keeping course that he completed and explained to the judge, the administrative law judge, about the knowledge that he acquired in that course and how he has incorporated that knowledge into his practice. And the panel will note that the record actually indicates that at the time that he was interviewed by the Arizona board, when that proceeding took place, he had already implemented electronic medical records. The record also shows that Dr. Patel has complied with all the terms imposed by the Arizona board, and that the Arizona board terminated the proceeding against him in April of this year, April 2017. At the hearing, there was another witness, Sandeep, that's S as in Sam, A, N as in Nellie, D as in David, E, P as in Paul, last name L-A-L, a physician, hospitalist with Kaiser Permanente Hospital, and he came in to testify as a character witness on behalf of Dr. Patel, testifying to his good values, morals, and integrity. In addition, Dr. Patel presented letters of support from his employer at General Medical and Physical Medicine Therapy Practice in Arizona, as well as from his wife, who's also a practitioner. Now, here's the important part, members of the panel. Based on the consideration of all that evidence, including the consideration of the record of the Arizona proceeding, the administrative law judge made some findings. She noted that Dr. Patel successfully complied with the conditions imposed by the Arizona order. She noted that the factual circumstances underlying the discipline in Arizona occurred way back in 2012 to 2014, and that respondent has changed, or that Dr. Patel has changed his practice in many ways since then. Now, I want to stress to the members of the panel that in considering this non-adoption, there is a statute in the Business and Professions Code, and it reads, when considering a proposed decision, the panel shall give great weight to the findings of fact of the administrative law judge. Now, the word is shall, and that's a mandatory duty imposed on this panel. And the reason for this rule, members of the panel, is that Judge Anderson had the opportunity to hear the evidence firsthand. She was there in the courtroom. She got to observe the witnesses. She had the opportunity to observe the demeanor of the witnesses, and by doing so, evaluate or assess the credibility of the evidence that was actually presented live before her at that hearing. The difference now, of course, is that you as members of the panel have a transcript, you have the exhibit, but the reason for this rule is that it's not quite the same. When you're there in person, you have the opportunity to make these credibility assessments firsthand rather than reading the testimony from what we call a cold record. So that's the rationale behind that rule requiring deference to the factual findings of the administrative law judge. And I'll point out also that this rule has evolved in administrative practice and evolved in such a way that the agency may not disregard an administrative law judge's credibility findings unless there is substantial evidence undercutting the reliability of the testimony found credible by the administrative law judge. That's evidence which a reasonable mind might accept as adequate to support a conclusion that the administrative law judge was wrong about the credibility of the witnesses in spite of the advantage of having heard the testimony. Now, I submit to you, members of the
Mr.
panel,
Garcia, I
that
need
there
you
is
to
no
repeat
evidence
that
but-
again. I didn't hear everything.
Hello?
I need you to repeat it again. You said that the panel may not disregard the credibility findings of the administrative law judge unless, and if you could go through that again. Some of the words I missed.
Unless there is substantial evidence undercutting the reliability of the testimony found credible by the administrative law judge. And I submit to you that there is absolutely no evidence whatsoever, much less substantial, that undercuts the reliability of the testimony found credible by the administrative law judge in this particular case. And of course, there was no evidence offered to the contrary. The complainant offered no evidence to undercut or undermine in any way the showing of rehabilitation presented by Dr. Patel. And just so that we're clear on this, the administrative law judge took note of the following factors.
Excuse me, you have 5 minutes, sir.
Sorry, I couldn't hear that.
You have 5 minutes.
Okay, the two patients were seen in 2000 and 2014, and there is no indication of any other incident or misconduct in the 3 years since that time. And this connection, I want the panel to know that there is case law that says that there is no truer indication of rehabilitation than a person's sustained law-abiding conduct over an extended period of time. The administrative law judge also noted that Dr. Patel no longer engages in hormone replacement therapy, which is the particular line of practice that led to the issues underlying the Arizona order. The court also took into account the fact that Dr. Patel accepted responsibility for the conduct that resulted in the Arizona action, and that he gained valuable insight from his experience in being disciplined by the Arizona board. And further, that he embraced and applied the knowledge that he acquired from the record-keeping course that he has successfully completed, and that he has complied with all conditions of the Arizona order. It was for that reason that the administrative law judge concluded that all things considered, a public reprimand and a requirement that respondent complete a prescribing course or practices course will be sufficient to protect the public interest. There's nothing in this record, members of the panel, to warrant or justify anything more than a public letter of reprimand. Dr. Patel has accepted responsibility, has shown his rehabilitation, and has changed completely the kind of practice that led to these issues in the first place. So there really is no reason to place Dr. Patel on probation. A letter of reprimand with a condition that requires him to complete the prescribing course is more than sufficient to protect the public interest. Thank you very much.
Thank you. Proceed.
Thank you, Your Honor. I want to start off by saying that this case raised a lot of serious issues regarding inappropriate prescribing and inadequate record keeping, and it did deal with 2 patients. Here, the respondent departed from the standard of care on 11 separate instances, and I wanted to summarize some of those. For example, one of the findings from the Arizona board was that he prescribed controlled substances without a medical indication, and you can find that at Exhibit 3, paragraph 16. In addition, he issued those controlled substances without conducting physical examinations. That's Exhibit 3, paragraph 22. He also failed to monitor vital signs, and that's at same exhibit, paragraph 18. And there was a finding that he caused actual harm to the 2 patients because he subjected them to unnecessary treatment. And that's Exhibit 3, paragraph 24. And then in addition, there was findings of the record-keeping issues. So despite these serious deficiencies that deal with patient care, the proposed decision significantly departed from the board's disciplinary guidelines and recommended a PLR but no probation. So no oversight, no way for the board to make sure that the respondent does not make these same mistakes again. And so we would ask that the board, in this case, follow the guidelines as they set forth the discipline that the board has found to be appropriate and necessary for the various identified violations. These guidelines were carefully considered by the board, and they were adopted by regulation, or as regulations, excuse me, and they have been in place for decades. Based on the doctor's unprofessional
I'm
conduct.
sorry, you said these guidelines have been in place for decades?
Correct. They have since the 1970s.
These specific disciplinary guidelines?
Not these exact ones, but the board's disciplinary guidelines were instituted in the 1970s, and they have been amended, of course. Based on the doctor's unprofessional conduct that I described earlier, the board's guidelines require at a minimum that he be subjected to a period of probation with practice monitoring, prescribing course, and a requirement that he maintain access to his drugs and drug inventories. And I'd like to also point out that public reprimands are in the guidelines meant to deal with situations that deal with a single patient. And again, here we are dealing with more than one patient. I'd like to also point out that in the proposed decision, they do state a basis for departing, but we would suggest that those bases that are explained are not sufficient to overcome the serious deficiencies in this case and do not constitute a basis to depart from the guidelines. So I'd like to go over some of those bases. The first one is that the doctor is no longer doing this type of work, that being the hormone replacement therapy. However, the doctor did testify at hearing that he is now doing pain management and working with addiction patients. Now, this type of work has the same potential to raise the same type of issues that, I noted regarding the inappropriate prescribing. And so this is more the reason why we do need oversight so that the board can make sure that the respondent has, learned from his prior mistakes and implemented changes that are not just a response to, being on probation in Arizona, but rather a change in his practice as a whole, and that is maintained over a sustained period of time. Another reason that the proposed decision lists for departing is that the doctor has accepted responsibility. We would state that at the hearing, the doctor several times testified that this case was primarily a documentation case, but that is not what this case is about. The guts of this case was not documentation, not technical violations. This was actual patient care departures from the standard of care, and patient harm was one of the findings. And in the briefing that we submitted, you can find the citations to the transcript where the doctor stated that this was the worst error he committed was that he didn't maintain his documents. In addition, when you do look at the transcript regarding his Arizona disciplinary action, when they asked him about, the inadequate record keeping, he stated that while he accepted full responsibility, he said the reason that those errors occurred was because he could only spend a few hours on the documents, on the charts. So again, minimizing and deflecting rather than taking full responsibility. Another reason that was given in the proposed decision is that, the Arizona order took care of it, meaning they already issued discipline. But in California, we have a system to deal with these type of violations, and that is the board's disciplinary guidelines. They're the ones that govern, not Arizona's. And so the Medical Board of California is not bound by what Arizona did. It doesn't have to mirror that order. And we also heard the attorney state that there's a credibility issue here. That's not what is at issue. That is not what's relevant. We're not saying the doctor is being dishonest. There's no allegations of that or anything like that. What's relevant here is that the board's guidelines do apply, and we are asking that this board members implement those, and these guidelines are meant to address the deficiencies at issue here. And again, a term of probation is necessary so that we can make sure that the doctor truly has changed his practice, and especially given that he's going to be still working in pain management and addiction. And it is our belief that a disciplinary order with the term of probation will ensure that he gets fully rehabilitated and that the public is protected. So another point that I wanted to make, though, is that there's been mention of the passage of time, but if you look at it, the doctor has just recently finished his Arizona probation. That was in April of this year. So in fact, he's only been without issue for about 5 months without having a board peering over his shoulder, so to speak. So we would respectfully request that the board issue a disciplinary order that is consistent with the guidelines, that includes a period of probation, that has oversight and monitoring, that it includes a prescribing course and medical record keeping, access to his drug inventories, and all other standard terms and conditions. Thank you.
Thank you. Your 5-minute argument, sir?
I beg your pardon, I couldn't hear you.
Your 5-minute argument?
Oh, thank you very much. Well, here's what really concerns me whenever I come to a non-adoption proceeding. All of a sudden, the term guidelines takes on another meaning. I mean, guidelines are guidelines. and they could be, the administrative law judges and the board can deviate from guidelines. They're not fixed rules that require a predetermined sanction of any kind. That's not what guidelines mean. That's not what they mean, and I think it's very, very misleading to say, well, we have the guidelines, we have to follow them in every case. That's not the case. You can deviate from these guidelines if you have mitigating circumstances. Mitigating circumstances obviously involve rehabilitation. Now, there's been some talk about the passage of time. Oh, it's only been so long since the Arizona order. No, the passage of time should be gauged from the last time there was any incident that led to discipline, and that was 2014. That was 3 years ago, and there's been no other incident since then, regardless of the kind of practice that Dr. Patel is now engaged in. And I think the administrative law judge got it right, that, look, a letter of reprimand is sufficient to protect the public based on all the evidence I've heard. And with the prescribing course attached to it, that would assuage the concerns that Ms. Evans has raised about the fact that Dr. Patel is still engaged in addiction medicine. That would address that concern. But really, we have to look at it. The Arizona board, where this conduct took place, looked at it and said, this is all we need to protect the public. Now, I agree with Ms. Evans. This board is not bound by what Arizona did, but the administrative law judge concluded what Arizona did informs, at the very least, informs what should be done in this case. And I also take issue with the question of credibility not being relevant. When a physician gets on the witness stand and testifies to his rehabilitation, testifies to acceptance of responsibility, testifies to how he has changed his practice as a result of being disciplined by Arizona, testifies to those matters that are all about rehabilitation, his credibility is on the line. Because an administrative law judge could very well say, well, I don't believe you. I don't believe you're rehabilitated. I don't believe you're being honest with this tribunal. So credibility is at the very core of findings relating to rehabilitation. This doctor has rehabilitated himself. He's no longer engaged in the kind of practice that led to these issues. He's demonstrated that by complying with everything that Arizona asked him to do. And again, talking about guidelines, we're not talking about hard and fast, inflexible rules that have to be imposed like cookie cutters in every single case. That is a complete misapprehension of what guidelines are meant to be. Thank you.
Something about the pain management. 4 days out of the 5 weeks, this is for the physicians on the panel, they're probably thinking traditional pain management. Monday through Thursday, I do medical marijuana certifications. I do not prescribe pain medications on those days. I am just reviewing records.
I'm sorry, I can't hear. Was that being addressed to me?
No, it wasn't to you, Robert. I was addressing the medical board.
I think you need to speak up, though, so that he can hear what.
So, there we go. So, all right, so just a clarification for the physicians on the medical board, Your Honor, that my pain management specialty is really medical marijuana certifications from Monday to Thursday. I do not prescribe narcotics or any of that type of behavior. I do not do any invasive procedures. I just review records and discuss patients' use of cannabis. And then addiction medicine is on Fridays.
Thank you. Proceed.
In this case, the board's primary mandate is to protect the citizens of California. And the guidelines are what the medical board has used in these situations. And given how egregious the violations were, the only way to protect the public in this case is to make sure that there is some oversight, to make sure that the doctor is prescribing controlled substances or dangerous drugs in an appropriate manner. And in Arizona, he never had any oversight, no true oversight, no monitoring to ensure this. So California, the medical board is well within its right, within the guidelines, to issue an order with a term of probation and the necessary conditions that go along with that.
Are you making a recommendation of a term of probation?
The minimum is 5 years probation with a prescribing course and with a practice monitor, and also with a medical record-keeping class, given the record-keeping issues, access to drug inventories and all standard terms and conditions.
Any questions? There are no questions from the panel members or the administrative law judge. So thank you very much. We can recess at this time and go off the record. Thank you. Thank you, Mr. Garcia. We're going off the record.